Thank you, Sarah. The OEO's impact assessment says that trans people could face a disproportionate risk of violence and sexual assault as a result of this code. What's your reaction to that?
I think we recognise that there are certain elements of what we now understand the law to be, which does disadvantage trans people compared to what they thought the law was. And what we've tried to do with the code is to make it clear how service providers, for example, can follow the law in a way that protects the rights of trans people. We make it very clear, for example, that it wouldn't be proportionate for service providers to be, checking the sex of everyone going into toilets where they're, kind of ancillary to the main service. And so we have tried to deal with that because I think it's really important that the starting point of the code, as in the starting point of the Equality Act, is that people should be treated equally and fairly in a way that enables them to live with dignity. There are exceptions to the sort of general prohibition on discrimination, so you can't discriminate, but there are certain circumstances where that's possible. For example, around age, around provision of single-sex services, around...
Going specifically back to the risks that the OEO impact assessment highlights, do you not think that's incredibly serious? This is a group that is already at disproportionate risk of violence and sexual assault, which is now being put at increased risk because of the actions of a body that is supposed to stand up for equalities and human rights.
Well, I think there's a couple of things here. I think, first of all, the OEO's impact assessment was going beyond looking at what the code was to looking at the legislation. There was no evidence provided for some of the things that they said might happen as a result. I think those are serious concerns that we need to look at and monitor and take seriously. But I also think this is not, what we set out in the code is not us making the law. It is us explaining to people what the law requires. And in this instance, where you are providing services, single-sex services or services separately, that needs to be on the basis of biological sex. But we also make very clear that that should not leave trans people without access to services, and we give specific examples of how you could do that.
Your code suggests that employees of a business should enforce restrictions based on evidence such as, and I quote, the individual's physique or physical appearance, behaviour or concerns raised by other service users. Can you please define specific elements of physique, physical appearance and behaviour that you would suggest it would be appropriate for staff to base their concerns on? And can you tell us where in the Supreme Court judgment it requires this?
I think that what's required here is to take a common sense approach, right? So we are talking about, what the law requires and what our code says is not that people should be judged on how well they perform masculinity or femininity, that the actual requirement is whether or not somebody is male or female. And in most instances, we expect that when rules are set, people will follow those rules. There may be some occasions, and as we make clear in the code, the response of service providers has to be proportionate. So, for example, it wouldn't be proportionate to have somebody checking who goes into toilets. But if you are, for example, running a women's refuge, then it is legitimate to be able to make decisions about who can and cannot come into that refuge if it is a single-sex service. And
that already happens on a case-by-case basis, though, and has done for many decades. Specifically,
I think the thing about a case-by-case basis...
Let me finish, please.
Okay.
Specifically on the elements of physique, physical appearance, what is it specifically? Is it height, build, hairy legs, face shape?
I think the problem that we get into in this area is people put themselves into a position where they either say you can always tell or you can never tell. And I think actually we're in a situation where we know there is no legal documentation that you can ask for to prove somebody's sex. However, a common sense approach would understand that, for example, very many women will have had an experience of being in a pub or club toilet where a man has walked in drunk and they've said, mate, I think you're in the wrong room. That has been based on physical appearance. And we make those sorts of decisions all the time. We make those sorts of judgments all the time. But what we are clear about is this is not about how somebody dresses, whether somebody has short hair, how well somebody performs femininity or not. This is exactly about somebody's sex and whether or not they can access services. And as I say, most people we would expect to follow the rules.
Dr. Stevenson, that example that you gave about a nightclub toilet, a man walking into a women's toilet absolutely drunk, what is there to stop that man now saying that I'm a trans man? And how can they prove or disprove to the other users of that toilet that they are or are not a trans man?
Well, I mean, you have the same argument for what is to stop a man previously walking in and saying, I'm a trans woman and I've got an entitlement to be in this space, because there's no requirement in terms of how people dress or present. I mean, there are people who are going to try, who may try and use an excuse to access a service. I think in actual practice that will be dealt with in a kind of common sense and practical way. I think the idea that under the previous setting, nobody would ever misuse the rules, and now under what we now understand the law to be, the rules are widely open to misuse, is difficult to understand.
Thank you. I'm hand back to Nadia, and I know some others want to come in.
What strikes me is that these are the same stereotypes that women have been trying to escape, and you haven't stated where in the Supreme Court judgment this is required, and that's because it's purely a product of the EHRC, isn't it? It's not actually in the judgment. Do you agree with the Minister who told the House last week that most people have the common sense to step in where necessary if they perceive someone to be entering the supposed wrong facilities?
So there's two things here. First of all, the question of adherence to stereotypes. It's not about stereotypes. It's about what somebody's sex is. This is about whether somebody is male or female. We have had previous versions of advice and policies set by all manner of organisations that have said people should be allowed to access services based on how they identify or present. That is exactly about their adherence to particular stereotypes. What we're saying...
Less than a minute to answer the question about the Minister, please.
The question about the Minister in terms of common sense stepping in. I mean, our code does not cover what members of the public acting in a private capacity do. That's not our job. Our job is to provide guidance for service providers. We have been clear that service providers' response to this has to be proportionate, and I think we would say in most circumstances, if people have concerns, it is probably better to speak to the manager or the owner or whoever is on site than to try and take matters into their own hands. But obviously, as I explained in the first thing, which is similar to what the Minister said, there are common sense situations where people will say, you know, you're in the wrong room.
Thank you very much, Nadia. Christine and then Alex, you've got follow-up questions.
Thank you very much. We haven't actually met before, so thank you very much for coming along. Just the questions that we've just heard and the answers seem to me to point up the whole basis of the issue that people have perhaps expressed concern over, this common sense approach. And, you know, how do you know if, you know, on what grounds does someone look like a man or a woman, and when do you interject? Once you've done that, once you've said that my common sense tells me that this person is not a biological woman, how did they prove it? How did they then say, yes, I am a biological woman and I can use that facility if, as you say, there is no certificate, there is no paperwork that they can produce, when actually surely that was the whole point of the Gender Recognition Act and gender recognition certificates, so that we had a way of saying this person is entitled to use that facility.
Well,
how do we do it now?
I think. I mean, there's a few issues here. So first of all, I mean, one of the things that the Supreme Court pointed out was that making access to a service dependent on whether or not you had a certificate, which was confidential, was not a satisfactory way of resolving things. We do have an issue that we don't have any documentation that reliably proves sex. Nevertheless, we still manage to operate all sorts of single-sex services very effectively because the vast majority of people follow the rules. And we have single-sex toilets at the moment. We don't have to check the sex of people going into them. There are organisations that run single-sex violence against women services very effectively at the moment. I think that there is an issue that there is no legal documentation. I fully accept that, and that's recognised in the code. But that doesn't mean that these services aren't operable.
But my point was, if to use the terminology of the Supreme Court and the guidance, a biological woman is challenged going into a single-sex space for perhaps good reason on the part that, their common sense tells them that this may not be a biological woman. How do we prove that we are?
Well, in most circumstances where people are challenged, as soon as they open their mouth, say something, it's normally, from my experience, somebody catches a glimpse out of the corner of their eye and isn't sure and checks, and somebody says, I am in the right place, I'm a woman, and that is fine. That's how things operate all the time right now.
When someone says to you, oh no, I am a biological woman, how do you know that they're not?
Well, what we explain in the code is that the decision you make has to depend on, the service that you're providing, the seriousness of it remaining single sex, what the evidence is, if there has been complaints, all of those sorts of things. But we have operated for decades with legislation that has allowed for single sex services, and we have managed to deliver those very effectively. From before the Gender Recognition Act, there's provision in the original Sex Discrimination Act allowing for single-sex services. We have been able to operate those effectively. And by and large, it's dependent on people following the rules. And then if they're not followed, on people taking kind of proportionate and sensible action and sensitive action, because we do talk in the code about how you ask and in ensuring sensitivity, for example.
Thank you very much. Alex Brewer.
Thank you. I just want to follow up on this in a bit more detail because, specifically on this point about common sense. If we go back a few hundred years, it was common sense that the earth was flat. And if we go back 200 years, it was common sense that women were far too emotional and sensitive to vote. So I would argue that common sense isn't actually that common, and my interpretation of what might be common sense might be very different to somebody else's. This is a code of practice, which is, as far as I understand it, and please correct me if I'm wrong, guidance on the practical implications of the law. And this new code of practice has come about because of a very high-profile court case. And so businesses and organisations and charities and so on will be concerned about litigation and how they can make practical implications to avoid very expensive litigation on their watch. So they will want to know exactly, not how, use a common sense approach. Well, what does that look like in practice? And that's what they're looking for. And my question is, the guidance talks about in a number of places comfort, people's comfort. So my question to you is, in situations where different groups' sense of comfort directly conflicts, how does the EHRC expect providers to weigh those competing claims in a consistent and lawful way to avoid litigation? And will the code be supplemented with a clearer decision-making framework to avoid inconsistent or discriminatory outcomes?
Okay, so there's a lot in there. I mean, on your first point on common sense, I mean, yes, I would agree. Maybe common sense is the wrong term. What I'm trying to express is that we have had single and separate sex services for decades, and we have not had problems with being able to decide who is and isn't allowed into them. And we recognise, I mean, the code can only tell people what they can do within the law, and we are in a situation where there is no legal documentation that you can ask for to prove somebody's sex. That's a fact. So we can't say check for this or check for that, because that doesn't exist. In terms of kind of additional guidance or making things clear for people, I mean, I think what the code does is set out very clearly what service providers should do in order to avoid, as you say, expensive and time-consuming litigation, and across all protected characteristics. And in all of them, there may be areas where it's not immediately apparent what somebody's protected characteristic is, and you might have to ask. You know, there are invisible disabilities, you might not know if somebody's pregnant, age, some of those things you can prove, some of those things people might not have evidence on them on the day. We are certainly looking at areas where we think additional advice or guidance might be needed, for example, around charities where there's particular complexity in the law, and around particular types of services that might have to make difficult decisions, following on the code. Just one final point, which is that we didn't update this code because of the Supreme Court judgment. Work to update the code started significantly prior to the Supreme Court judgment, and we had actually submitted one version of the code to the Secretary of State before the Supreme Court judgment. We then had to revise it to take that into account.
Thank you very much. Alex Sobel.
Thank you. So under Article 8 of the ECHR, people have certain safeguards, including personal autonomy, social identity, mental and physical integrity, and the right to establish relationships without government interference and data privacy. Is your assessment